Hello, my name is Bob Arnold. I'm an attorney here in Miami with the Victoria Law Group. I'd like to talk to you today about Chapter 11 bankruptcy. Chapter 11 bankruptcy is a tool that companies under distress often use as a way of reorganizing and reprioritizing their debt obligations and oftentimes their corporate structure. So the goal of Chapter 11 is to emerge from the process after it's complete as an ongoing viable concern. Obviously, two of the bigger examples in the United States recently are General Motors, which saved a lot of American jobs and emerged as a viable company, and Lehman Brothers, which emerged as a debt-free company with $11 billion in cash. One of the great advantages of a Chapter 11 is that it gives you what's called an automatic stay. If there are any creditors, that have filed a lawsuit against you, if you're facing a foreclosure, if you have judgments against you, this automatic stay gives you a period of time in which you can basically take a breather, call a timeout, drop a smart bomb, and try to get yourself organized. And they can't bother you, harass you, attempt to collect from you while you're getting yourself organized. That is one of the primary benefits of Chapter 11 bankruptcy, honestly, of any bankruptcy, the automatic stay. Another benefit of a Chapter 11 plan is that it gives you an exclusive right for 120 days to put together a plan. And what this exclusive right means is that you are the only one who has the opportunity to put forth such a plan. The reason this is important is because you can be forced into bankruptcy involuntarily by one of your creditors. One of your creditors could say to the judge, "Hey, judge, I think this guy's in trouble. Can we put him in bankruptcy, and that way we can organize his debt, and I want to be in line for my share of it." With the exclusive right for 120 days to submit the plan, what you're basically saying is, I know what my debts are. I'm going to organize my debts, and I'm going to put together a plan in order to pay off my debts, and no one else has an opportunity or a right to do that for 120 days. Also, if it takes you a little bit longer because your books are messed up or for any other reason, you can ask for an extension on the 120 days, but 120 days is the standard. So then what happens? Once you put together the plan in that 120 days, comes the confirmation stage, which is the confirmation of the plan. And the plan is really confirmed by a vote of the creditors. Any of the creditors who you owe money to, or judgments, or any other thing any other kind of obligation such as that, they have the right to vote on your plan. So if the plan is fair and the plan sort of looks like it has a chance and it's blessed by all the parties involved, it's usually just a formality, the so-called vote. It's usually just a formality. You put forth the plan, your creditors say, yes, we accept the plan, and by accepting the plan, they're usually agreeing to take a little bit of a haircut on the debt that you owe them. If you are successful in completing the Chapter 11, the plan, and completing the plan, the ideal is that you'll emerge as a thriving, ongoing business, and you'll have treated your creditors as fairly as you could have treated them and paid back to the ability that you could without completely forcing the company into a Chapter 7. This is one of the aspects of Chapter 11 that's really usually hard for clients to swallow. Chapter 11 is very expensive. A Chapter 11 is almost as expensive as a normal litigation. In fact, it can be as expensive as a normal litigation. It can be more expensive than a normal litigation. And why is that? That's because there is a lot of paperwork that needs to be filed with the court in order to effectuate a Chapter 11. There is a lot of negotiations that need to take place with the creditors in order to effectuate a Chapter 11 plan. So if you're thinking about a Chapter 11, really, at a minimum, you need to be considering a $20,000 investment, because that's on the extreme low end. I know many bankruptcy attorneys in Miami who will not touch a Chapter 11 for less than a $50,000 retainer, and that's just the retainer. That does not include the fees going forward. So you should think about that. If you're considering Chapter 11, it's a wonderful opportunity to reorganize, restructure, and get yourself set up in a way that you can to go forward. However, it's also extremely expensive. Extremely expensive in that, unless you are a GM or a Lehman Brothers and you're sitting on billions of dollars of cash, you ought to consider it very carefully. My name is Bob Arnold. I'm an attorney here in Miami. Look forward to having a conversation with you if you're considering any of the corporate restructurings, Chapter 11, motion to dissolve, or applying to have a receiver appointed. Thank you.